As I mentioned before, this panel is going to be IP and the music industry, current challenges of copyright and neighboring rights. So they are going to talk about the evolving landscape of the copyright laws and what's the impact of the new technologies, particularly AI. And we are very happy to have two experts. We have Amaia Ramón. She is the Senior Manager and Legal and Business Affairs at Sony Music Publishing. And she's a lawyer specialized in intellectual property with a particular focus on the music industry, entertainment industry. Thank you, Amaia, for being here. And we also have Ibán Garcia del Blanco. As I mentioned before, he's a member of the European Parliament. He's also a coordinator of the Socialists and Democrats group in the Legal Affairs Committee. And he's done an outstanding work as an advocate for the creative industries. And, well, he has earned a recognition in the industry for all his work, so thank you for that. I'm not going to take you any more time because I think you're going to present yourselves a bit, so the word is yours.
Thank you.
Thank you.
Okay, so good morning, everyone. I hope you're enjoying these digital licensing sessions. I am so honored today to have with us Ibán Garcia del Blanco. How are you feeling, Ibán, this morning?
Fine, thanks.
So Ibán
I'm
is so as Nerea said, he's a member of the European Parliament, and he is the author of the report on cultural diversity and the conditions of the music authors in the European streaming market, right? He is also been part of the drafting and negotiation of the brand new EU AI Act, as you may all know, that was approved late March this year. And so these are the two main topics that we are going to cover this morning. So to begin with, I'd like to mention a study commissioned by GEMA, which is the German Collecting Society, on the revenue in the streaming market that shows how of the 100% of the subscription fee that a user pays to the platforms, only a 15% goes to, of the net revenue goes to the work, then split between the authors and the publishers, while a 55% goes to the master recording. Finally, it's a 30% remaining that goes to the streaming platforms. So it's true that this study is made in Germany, but the situation is quite similar in the rest of Europe. So this gives us a quick impression on the conditions of the authors in the streaming market in Europe. And some of the reasons for these kind of pitfalls, right, could be found in both the size of the pie that David mentioned previously, and we will mention later, and also the distribution of the pie I just mentioned with these quotas from this German study. So, Ibán, I know that you, in your report, mentioned certain ways to solve some of these issues. So could you please briefly explain to us the key points of your report?
Yeah, I'll try to. Thank you so much, first of all, for the invitation to the organizations. It's a real pleasure to be in Barcelona every time, but today even more because it's about something that I care so much about, and of course, sharing the panel with you is another pleasure. And in that regard, speaking about that, we identified as European Parliament some of the flaws that we pondered that was a real problem in a subsector of the creative sector, that is the music sector, that entails a paradox by itself. That is the first that was adapting to the digital scheme, the first of them. It's the front runner in many of the new trends about the implementation of new technologies as artificial intelligence and so on. But at the same time is behaving like a kind of icebreaker for the rest. The rest of the cultural sector in that way, I think that is enjoying the fight that the music sector is doing and the adaptation that is doing to these new schemes. And in that regard, as European Parliament first, we were aware that we have some mandates and goals that are mandatory for us. That first is to take care about cultural diversity, cultural plurality inside the European Union. Of course, about the creative and cultural sector, it was identified in the past by the European Parliament as one of the 14 key sectors and key priorities for the European Union. And speaking on that is quite evident, quite clear, but taking a look to the landscape is not that clear, but it's quite clear that authors and performers were the basic for the sustainability of this music sector for the future. And yeah, the data that we had, and we tried to find out in that way the best figures and the best data, set us this kind of distribution of revenues. And I think that it's quite evident too that this distribution, this allocation of revenues is not sustainable anymore, any longer in the future. If we are speaking about creating new trends, exploring new trends, to make sure that authors and performers could have a kind of long life careers, it's quite evident that we need to fix some of the flows. And in that sense, the European Parliament made this report that was approved in January in the plenary of the European Parliament in Strasbourg. It was approved by a huge majority of almost 600 MEPs. It's not binding. I have to say that it's not binding, but it's a kind of political will that is quite powerful, speaking about the future. And we made this kind of photograph about the state of facts in this moment, trying to identify which is the key role of every of the actors in the value chain, and of course made provisions and made recommendations for the future. Does it mean that we are thinking on regulate every aspect that we think that it must be enhanced? Not at all. Of course, we are waiting for the sector, and we are waiting for the music market to fix itself in the way that could do it. And in that regard, it was so interesting to listen some of the initiatives that some of the platforms and another key players in the market are taking on board in this moment. But eventually, if it would be not fixed, we have to take action by the public sphere too.
Yeah. Okay, so like going more into the specific, there are currently in the DSPs, as you mentioned, certain pitfalls. One of them is the opacity in the creation of playlists, right? Because they tend to include trendy music in order to please a larger number of people, mainly those that are curated by algorithms, right? So this puts us at risk cultural diversity because it tends to be more homogeneous. Another pitfall could be found in the, as David said before, the companies that buy streams, also known as click farms. So I know this is something that maybe the industry is the one who has to solve it, but do you have any, or does the report plan provide any type of ideas or for this?
There's a huge debate on this kind of transparency at a huge range. No, speaking about artificial intelligence, for instance, that is mainly the tool that is being used for create this kind of lists and this kind of proposals for listeners and for people that is in platforms and so that. And for that, in a general way, the European institutions took the action to try to grant more transparency, more light in the way that this kind of lists and recommendations are made. And in that regard, the report is speaking about transparency in the creation of algorithms and transparency about the way or the will that is behind the way these algorithms are made, and of course these recommendations are made. By the way, some of these provisions about transparency were taking into account, we're taking on board of the by the Artificial Intelligence Act. This is one of the steps that we took already. So it is important that in the future we could entail any other of these provisions. As I said, and that is quite important, and I'd like to underscore it. Our report is not binding. I think that the most important thing or the most important conclusion of the report is that we have to fix the situation, and in that regard we need to gather all the stakeholders together in a mutual and a balanced dialogue. Till this moment, we didn't have that. This is an evidence true.
Yeah.
And trying to fix together the problems. This is not a game, a shaming game. No, we didn't try to point out to any of the players of the value chain, because I think that this is worthless. I think that we have to fix everything together.
Yeah. Okay, I'd like also to talk about the remuneration for authors that you talk about in the report, because it's quite surprising that in the almost 15 years that we've been using streaming music, the subscription fee hasn't almost increased, in contrast with the VOD platforms, for example. So I know there's a lot of talk now about a change in the model of remuneration in the DSPs. So what can you tell us about it?
It's a sensitive matter, because it was so tough for us as European regulators to ask for high, no,
an increase,
and increasing the fees, no. But at least we touched upon slightly in our report, because it's a key part. We have to make sure that these music platforms could have a kind of sustainability in the future, and for that we need to change a little bit the culture. And speaking about that, and speaking about Europe, there's a worst case, the worst case in Europe, that is Spain, because we are the less country in paying for the use of this kind of platforms. And I think that we have to keep a kind of public debate on that. This is not sustainable in the future. This is not a sustainable scheme in the future. So we need to change our mind about this kind of behavior if we try to make something that is fair for every of the actors of the value chain. Because, as I said, it's not a matter of shaming the platforms. I think that it does not make sense. It's not that. We need to improve the conditions of consume as well for platforms.
Yeah, this is an open debate, and we can spend hours and hours here speaking about it. But so, like, now moving, just conscious of time, moving now into the real deal this morning, and I know everyone here is expecting to hear about it, which is artificial intelligence. You were part of the drafting and the negotiation of this brand new law, and which was negotiated for over 4 years, right? And so could you please tell us, I know one of the keys of this law is transparency, but could you please tell us what this law briefly aims to achieve?
This law, as a whole, no, in a general approach, is trying to strike the right balance between improving the conditions of innovation, or about feeding the startups, feeding the initiatives, trying to create a European digital market too, in cooperation with all member states, trying to do these kind of things. But combining everything about taking care about some of our common values that are important from the collective point of view, such as gender equality or environmental sustainability, and so that, and of course, above everything, to take care about our fundamental rights. And in that regard, the law establishes a kind of layers from some applications of artificial intelligence because it mightness because it's quite powerful, that are completely prohibited. There's another step, another layer about some of the uses of artificial intelligence that are considered as high risk, and in that sense, it merits a kind of special controls from the very beginning, before the commercialization in the European market, and a control about all the life of all the cycle of the technology or the product that is using this technology. And there are some uses, applications of artificial intelligence that are considered as deserve additional tools of transparency. Speaking about IP rights, or speaking about the use of generative AI, this is under this umbrella of transparency. And there's a previous argument that I would like to say that is important to take into account, because sometimes not just in this music market or in the cultural sphere, the artificial intelligence law is not trying to solve every of the problems that could come across in the use of artificial intelligence. It's not meant for that. It's an additional layer. So speaking about the rest of the regulation tools that are functioning, that are ongoing in every of the aspects of our life, the use of artificial intelligence doesn't mean that everything is falling down. For instance, speaking about something that for us is quite important and it gathers us around this debate today, speaking about IP rights or authors' rights, the use of artificial intelligence is in that regard the same that the use of another tool that could be more handicrafted than artificial intelligence. But the artificial intelligence law trying to deliver some tools to the IP right holders to try to defend or to protect the rights.
Yeah, okay. Yeah, we'll speak about it later too. But could you please remind us when this law will enter into force? What steps are missing at the moment?
The final, at last, the final approvement was at the Council about 2 weeks ago. I remember, but it's not clear because we are final approving the law several times. I lost the count in the past, but I think that it was the last, and it's imminent to be published. From this moment on, there are different terms. Speaking about, for instance, transparency and generative models, we are speaking about 1 year. In a matter of 9 months, the Commission or the recently created Artificial Intelligence European Office has to publish the models, the templates for granting this kind of provision that are in the law. For instance, the model for this transparency for generative AI models in the use or not of IP protected rights. The general term for entering into force of all the law is 24 months, but there are some special terms. But importantly speaking, about what is at the stake for us, generative models scheme is going to be entering into force in 12 months, and the rest of the law in 24 months.
Okay, nice. So in the last year, we've all witnessed how a lot of large companies were using protected content, copyright protected content, in order to generate new content without asking for a previous authorization to the rights holders, leaving them, let's say, defenseless. But so you propose to solve this through transparency, as you said, but more specifically, what type of transparency tools does the law provide?
As I said, the law provides a mandate for the generative AI models developers and the providers into the market to publish the IP rights that were used for the training of the models. This is an important tool for the right holders in order to ask for their rights. And of course, there's another debate about about the way a right holder could oppose the use of this kind of data for the training of the models. But again, I would like to take advantage of the moment to remind that the Artificial Intelligence Act doesn't mean that the rest of the regulation falls down. Not at all. So from my point of view, it's quite clear that the use that were made till this moment for these developers of artificial intelligence generative models were absolutely unlawful.
Yeah.
Were absolutely unlawful, because they are trying to use this exception of data mining in the copyright directive, but it was not meant for that. Starting from a point that is quite important and is, again, so evident, but sometimes it seems that it's not that clear for some of the actors. Nobody couldn't opt for this opt-out provision on the copyright directive because nobody knew about this technology. This technology didn't exist in the past. Was hidden for most people. And I'm going to put a matter of fact on that. We were discussing the Artificial Intelligence Act law at the European Parliament after the presentation of the draft by the Commission, and in our law, generative model didn't exist because nobody knew about that. Even people, quite expert people, super expert, worldwide people about artificial intelligence were saying to us that generative models were meant for 5 years' time, 6 years' time, and suddenly it happened.
And it's now,
It was like an explosion. So I think that the use that were made by any of the models that are ongoing in this moment, and we know the names of that because are the famous, were using unlawfully the data mining, if they use that, the data mining exception. So I think that it's quite clear that we have to use the Artificial Intelligence Act transparency provisions in order to ease our claims against them. But in any case, I think that we are absolutely entitled, regardless the provisions of the Artificial Intelligence Act, to claim against us. Quite recently, by the way, because we were speaking at the side about that, I saw a recent decision that was taken by the Supreme Court about a question that was planted by OpenAI, and the court was so clear. There's no right to oppose to transparency by them for the use that they made in the past, and the right didn't fall in the past in any case. So for the right holders, the European right holders, will be the same, even taking into account that our copyright directive and our copyright and authors protection law at the European level is even more exigent than the US one.
Okay. Yeah, I like to go deeper about this text data mining exception and opt-out, opt-ins later, so that you all know, in case you don't, what this exactly is. And so another question I wanted to raise is that, well, actually I'd like to highlight the extraterritoriality of this law, right? Because what it means is that irrespective of what of where the model was trained, no matter if it was in Singapore, New York, or Korea, once that model or once the service of this Gen AI company hits Europe, they are going to be subject to this EU AI Act, right? So this is a change of paradigm, right? And so I'd like to know what sanctions that does the law provides for those who are in breach of the regulation. Like, what sanctions does the law provide?
Even the outcomes. This is important too. You can use, you can develop an artificial intelligence model in US, and you can run in the US market. If a client from Europe asks for a kind of essay or study about whatever, and it's used this artificial intelligence model, and this response, this outcome from this artificial intelligence model is going to be used in Europe, is under the umbrella of the Artificial Intelligence Act. In that regard, it's super extraterritorial. There's no way, or we try to. There's no way to escape, to get away from the running of the Artificial Intelligence Act. Speaking about sanctions, again, I would like to do this first claiming. The rest of the law is ongoing. The laws that could be of use in any of the cases. But besides, the Artificial Intelligence Act contains additional penalties from $30 million or €30 million, sorry, or the 7% of the total turnout of a company at worldwide. The quantity that is going to be taken is the higher. So you can figure out what does it mean for OpenAI or for Google, also that about the 7% of the total turnout. No, I think that we could pay our retirement in Europe just with one penalty. No.
Yes.
I hope so. So sorry.
Okay, so correct me if I'm wrong, but this law applies to those AI models that were issued after the entry into force of the law. But then what happens to those AI models that were issued before the entry into force of the law and that have ingested massive amounts of content protected in their models? Are there any plans to remunerate or compensate for this? And what responsibility will AI companies have in this regard?
As I said, the copyright provisions are ongoing, so you couldn't use unlawfully the rights from authors or performers or so that without their permission. So you're absolutely entitled to claim against them using this artificial intelligence additional tool or not, transparency tool or not. But speaking about transparency and speaking the next future, of course, or as you said, and this is good to know for people that could have a kind of interest on that. It's not applied for the current models that are in the market in this moment, but it's going to be used, or it's going to be in use for the next future in any of the updating of these models, or in the use of these models in another product, in another application of artificial intelligence. If I introduce ChatGPT, for instance, in my business, or in my plan, or in combination with my own artificial intelligence model, you have to respond for all the cycle, for all the rights life from the very beginning. So it's not to be in use for them right now, but it's going to be used in the future, because no one of them are gonna be updated in the future. No, that is quite evident too.
What's gonna happen then with ChatGPT 5, for example, is not public, right? Yet it's going to be soon. But so are you saying that with this new model, all the content that they have fed or they have trained for also GPT-4 it's going to be can be like there's a penalty there too.
It's straight really applied to these new models. So this is quite clear to bear in mind. They are going to be obliged by the law in the very beginning, in the very moment they updating the model. So it's a general obligation for any of the players of a new updating, as I said, an adaptation of the previous model to any other kind of business model. So it is going to be that in the future.
That's interesting. That's an interesting point, yeah. So we've talked about the inputs, which is the content we feed or we train the models with. But what happens with outputs, the other star of the morning? So the outputs are the results of this Gen AI process. And so the thing is, for me, I find watermarking a really useful tool in order to identify and differentiate content that is created with AI from the one that is not. But apart from that, beyond that, are outputs going to be protected somehow? And who is going to be the owner of those outputs?
It's a good question that I don't have a response for that. No, there's a debate ahead. It's quite important to bear in mind again that we'll have quite important debates in the future, in next future, I would say. And it's not just about some of the big riddles like that. No, what is going to happen with output in the way that could it be subject of protection or not in the future, but even about the application of the provision that are quite clear. For instance, I put an example in our dialogue before about the templates that are going to be published by the Commission. Depending on the shape of the templates, could be useful for authors or not, or could be an advantage for authors or for other of the players. So I think that you have to be quite warned. Quite warning about this development of facts, and I was so vocal in the past as MEP to the Commission in order to take on board all the stakeholders in order to provide these solutions. Because it's quite well known that they are in a constant dialogue, and they have to do in this way. There's no debate about that with technological players. But I think that it's important, like was in the past, that you have in mind that there are some other players that could have, like other fields of the life, confronting rights or confronting interests. Yeah. But speaking about that, I'm not trying to get away from the question. From my point of view, that is the only thing that I could put on the table. I think that we need to protect these outputs. First, in order to have a fair competition with the products of human beings. Just trying to at least put a kind of balance. I mean, not getting for free content. And speaking about plural and cultural diversity, that is important too, because the users or the commercializers of this kind of products could have the temptation to narrow the likeness of people in order to guide people to the most profitable and most easy to create by artificial intelligence models or styles.
Yeah.
So that is important. It's another important reflection.
Could be another genre, music, another music genre, the AI music. No, I'm joking. But
yeah. But yeah. I think that we are quite aware that there are some styles that are easily or could be easily replied than others, no? So this is important in one thing, and in the other hand, I think that is important that is not for free in the future. And the use of these outputs. And again, there's another debate, or there are two debates that are quite important. Where is exactly the line?
Yeah.
Where do we put the line between a production of artificial intelligence generative models or human production?
Yeah.
Which kind of use of these models is required to be considered a human work or not? Mm-hmm. This is an important thing. And another of the debates that might be important in the future, and this is not just for music sector, but for all the artistic sector, is about the prompts. Many people are arguing in this moment, are advocating in this moment for the protection of prompts. I don't have it that clear. I don't have it that clear. I'm quite honest on that. I don't have a conclusion on my mind about if it could be deserved or not.
I don't.
But there's a debate ahead, and about the response, about the answer to these questions will be the future of the sector itself.
Yeah, totally. We are in a very important moment to decide the way we go now. So, yeah. So, I'm just being conscious of time. I'd like to continue speaking about this, but getting more into the math, even more. I think if there's one controversial point in this law, that is the text and data mining exception you were speaking about before. Text and data mining is defined by the directive as any automated analytical technique designed to analyze text and data in digital form in order to generate information, including patterns, trends, correlations, or the like. So the law, this AI EU Act law, makes an express clarification that every single AI company must comply with copyright regulations, so that in case they use copyright-protected content, they must acquire a previous authorization from the rights holders. However, AI companies like Udio, Suno seem to be quite relaxed about it, and they are, because they are basing their model on this TDM, or text and data mining exception. So tell us exactly, what does text and data mining mean, and why are these companies escaping the law through this gap?
Yeah, they are using that as an excuse for the unlawful use of this for training the models. But yeah, it's quite clear in the redaction of the paragraph. It's quite clear that it's not considered the use of these data protection rights for the final goal that were used for create nothing less than models that are competing with human beings and with authors and performers in the real market. But besides, it's considered by the Commission, by the European Commission, that in the future, right holders have to opt for this opt-out exception in a clear way. And speaking with some of the officials by the Commission, they are going to be, or they have the intention to be, so exigent on that. And I mean, all right, I'll try to explain. It's not just about a mere declaration that you are not allowing the use of your data. You have to do it in a metadata way. You have to do it in an individual way. In this regard, the European Commission is, for instance, and speaking about your initiative at Sony, that I praise so much. It's not just about that a company are entitled to defend the rights of their their musicians or their performers, or it's not just about that a collective management association or entity are entitled to protect. No. You have to do it individually. I think that is not. It does not make it's not feasible.
No.
It's in practical is putting a lot of barriers to protect our rights. And I think that by the pressure that the market and the sector has to do upon the European Commission, I think that we'll manage to ease a bit this vision about this, the way in which opt-out option is going to be run. But again, it's just the European Commission approach. It does not mean that it's the lawful approach.
Yeah.
An eventual judge could say, as is natural, and in the same way that is happening right now in US, that of course a mere declaration, collective action could be more than enough to protect the rights. But again, we're facing another debate ahead that is capital for the future of the position of authors' rights and neighboring rights, of course.
Yeah, yeah, and also I think it's important to mention that we are speaking and we hear a lot about opt-out mechanisms, right? But there's also an opt-in mechanism too. So I think it's really, for example, some companies in the music industry, for example, Sony, are opting for the opt-in mechanism rather than this opt-out mechanism. So what I mean by this is that when you choose this opt-out, you are assuming that you operate under the text and data domain exception. While if you opt for the opt-in mechanism, you are saying that in case any third party wants to use your protected content, they need to acquire express and previous authorization, which is the express clarification I mentioned that the law, the AI Act, makes. And so it's also important to say that it's not the same, and we were speaking about it before, that what AI, generative AI, we're speaking, so generative AI makes is not text and data mining, or maybe not only text and data mining. Maybe it's a tool they need, but it's not the whole thing they do, but machine learning. Mm-hmm. So text and data mining is an exception in the law, but not machine learning. So they must, of course, acquire this license.
Absolutely.
So do you think this is maybe the argument to refute their arguments? Because they are saying, yeah, like we are speaking a lot about the lawful access. Also, the other argument is that it has to be publicly available. And so this is what OpenAI says. Like they cover their activity saying that what they did was publicly available. Like the content they used was publicly available. And that I've heard that from the CEO of the company. So, I mean, that's what they are, that's their argument. But fleeing a bit or getting out of these two arguments, I think one good point could be this, saying that it's not an opt-out what we're doing, but an opt-in because you are doing machine learning and not TDM. Like we are not under any circumstance under this exception. Right?
You explained it so well. I'm not going to go deeper in your explanation. That is quite good, and but let me to say first, this kind of companies are treating us like morons. It wasn't public available. It's quite absurd. It was protected. There were actions to protect these rights. They did it obscurely, without any kind of communication to the right holders or the representatives by the right holders. And they did another. They had another options at that moment. They could use, for instance, the millions and millions of data that are in public domain for training the models and for investigation and for search. It wasn't like that because they were meant to be competing in the real market with human beings and with the traditional market, for speaking in a way. So. This is quite clear. As I said, you did right and you said right and you explained right. It could be a model. Another of the debates that we have to keep is in which way we are going to ask for our rights against these companies. because again, European Commission is thinking in a model, in a concrete model. That is the model of micro-licensing, a model of, again, individual action, and a model that is not feasible, again, that is not feasible for right holders. It's a good model for this kind of tech companies. I think we have to be so vocal on that. We need collective action. We need to gather together in order to at least to balance a bit the competition, because they are so huge, they are so influential. I said at the very beginning, speaking about platforms, that it's not a game of shaming, and I'm not trying to do that, but it's quite noticeable, quite remarkable that their position are so might in the market, and in that sense they pressure so much. They have a lot of tools. They have armies of lawyers. They have armies of the technologists. So we need to compensate a bit, and this is the spirit at the end of the author's rights and the collective management of the author's rights. We need to balance this game by collective action, no? But again, it's another battle that we have to take in the future.
Yeah. Okay, so I think we're running out of time. So I just wanted to quickly mention that yesterday, Meta published that they are going to change their privacy policy in order to, like from the 26th of June this year, they are going to use all of our content, all the content of the users, to train their AI models. So that, just so you are aware, you can, if there's any artist or composer or here, so that you can make the opt-out, that you have to, they provide it, you have to fill a form saying that you don't accept to give your rights and so, but just like it showed up yesterday, and so it's important to mention. So apart from that, thanks so much, and let's start the Q&A.
Okay.
That I guess it's going to be.
But I can't help but commenting on your last remark. I would say to Mark Zuckerberg, welcome to Europe. We have important pieces of regulation. We have general data protection, and we have another law of data protection that were approved so recently too. By the way, I was reported on that too in a few parts. So they can declare whatever they like, but they are not entitled to do in this way in Europe.
Thank you. So Emmanuel from the Portuguese publishing company, Portugal. Are you not afraid that all this regulation will stop, or como é que se diz trabalho? Stop. Yeah, stop. Yeah, stop the innovation in this sector?
No. No, it's a common question, and it's a very good question because, of course, there are a worldwide debate on that. I think, on the contrary, I think that was a concern that some of even the members of the European Parliament had at the very beginning of our negotiation, because, as Amaia said, we were negotiating this piece of regulation for 4 years, but besides, we've started with another legislative proposal. I was the reporter on that, about ethical aspects of artificial intelligence. That was, in that way, the spirit of the draft that was published by the Commission. That was ultimately the law of artificial intelligence. There were some concerns on that. We had a real debate on that with some of our allies, world allies, like US. I had the chance to be in US several times and speaking with some legislators, speaking with companies and so that, and they have this concern. Let me tell you what happened last time I've been in US, about 4 months ago. I've been in Washington first, and then in Texas, in Austin. Even companies, at that moment, some of them quite reluctant with our Artificial Intelligence Act at the beginning, are advocating in this moment for a piece of regulation quite similar in US, because it issues legal certainty that is quite important to operate. legal entity in nothing less than 27 sovereign states. The same rules for 27 sovereign states. And of course, it grants no fragmentation inside the single market. The rules are quite clear. They don't have this chance in US anymore, because people, normal people, common citizens, are putting pressure upon some of the representatives about some of the dangers that artificial intelligence could entail. Speaking about, for instance, the weakest people, or speaking about underage people, and so that there's a kind of blockade at Washington, a legislative blockade on Washington. So some of the states, for instance, Texas, I had the chance to speak with the reporter of the Texas law this last time. Some of the states are taking action about state laws on artificial intelligence. So the big nightmare of companies is an internal US market absolutely fragmented. This is not the case for Europe. So they are advocating for a solution quite similar to us. Even more, speaking about Asian field that are the most reluctant, more or less, most reluctant to regulate some of the aspects. Japan is like a lone ranger, on that. I think that they are going to bend down. I'm quite sure of that. If you take a look at what is happening, for instance, in Korea, in South Korea right now, they are taking steps quite similar that we took in Europe in this moment. The last report that I think is so interesting about generative AI models are so similar and even more excellent than our artificial intelligence law. And I think that Japan will be the next for sure. As a matter of fact, they are creating their own offices in all the countries, even in Japan. And last meeting that I think was in Singapore last time, of these Western countries are going in this way. No, I don't have this. I don't have this concern. On the contrary, I think that will be quite good to boost innovation. And besides, let me say another thing. I think that that it is going to depend on our capacity to work together in Europe. It is going to depend on that, to gather resources all together. Because if not, we are not going to be a worldwide player anymore. We are going to be absolutely little in a huge market of huge investors like US, China, India. The problem is not the situation anymore. But if you take a look 2 years before, the problem is that the US is investing more than $30,000 million, China more than $10,000 million, and we all together we were in 1,000. No? So we can compete like that.
I have a question, David Serres from Unison. First of all, thank you, Amaia and Ibán, for this amazing conversation. We could spend another hour here easily, peanuts, like they say. So, for me, like taking on what Emmanuel said, just I remember like back in 2014 and 15, Community Association and all those guys were saying that the Article 17 or former Article 13 would kill the internet, and they were claiming all about that, and in the end, it just brought fairer conditions for the rights holders. So there's always this balance that Emmanuel was asking for, and that you so well explained. Other thing super interesting that you brought this approach on that the TDM exception from the directive wouldn't be applicable to this massive ingestion of or input, and that you brought the opt-in perspective. My question is, I have two questions. So first one, the extraterritoriality of the directive is also applicable if there is no input there is no interaction between a user in Europe and the engine in the US, let's imagine, but if there's a musical work produced or created by an European writer being used by a company in the US, but it's just they are ingesting, they are putting in the input a musical work written by an European songwriter, is that included also? That's a trigger for the extraterritoriality? It is. Okay, so second question is, are you envisioning currently in the European institutions any sort of legal mechanism to sort of support the initiatives like Fairly Trained and such initiatives where AI engines, they train themselves on licensed content, so they have like a benefit from the European lawmaker? Thank you.
I don't know them. I don't know this kind of initiatives. Might be ongoing. Might be, because as far as I know, there's a constant dialogue with the tech sector by the Commission, and I think that we have to be fair and we have to give some room to them to work on the development of the artificial intelligence law provisions, and not to put that pressure in every of the detail and every of the minute, but at the same time, be cautious. I think that we have to be cautious because, as I said, the other players are quite influential. So we have to take a note of that. And this was, as you said, this was the problem of the creative sector in the past. Because I consider one member more of this sector, we are so little in front of the biggest fishes on the pond. You know? So we have to work together and to be so cautious and so warning about that. No? But could be advisable to have this kind of tools. No? May joining the creation of the European Artificial Intelligence Office, the law is creating a dialogue board shaped by European institutions, the representatives of member states, the tech sector, and is foreseen to count on people from the civil society. So I was advocating, for instance, in the parliament to integrate trade unions, for instance, and for me it's absolutely indispensable that, for instance, collective management representatives could be on the table too, no?